Hi guys! Welcome back to the House of Law. It's me again, Attorney Aljumrani. At eto na nga, mainit-init pa ang aking suggested answers to Civil Law 1 Bar Exam. Ngayon, kung kakatake mo lang ng bar, warning, kung mahina ang loob mo, skip mo na lang muna siguro tong video na to. Balikan mo na lang kapag ready ka na. Alright, let's do this. Question number 1. Noel is the son of spouses Marie and Benedict. Benedict has passed away. For Noel's 7th birthday, his paternal grandparents offered to organize and pay for his birthday party. In coordination with Marie, the grandparents booked the party venue, signed the contracts with the caterer and the entertainers, finalized the guest list, and paid all amounts due. Marie promised to them to bring Noel to the party. A week before the scheduled birthday party, Marie decided that she would not bring Noel to the party and that she would instead take him on an out-of-town trip on the day of the party. Marie could not forget that her parents-in-law initially opposed Benedict's marriage to her because she was a former burlesque dancer. Marie did not notify the grandparents of her plan to skip the birthday party. During the party, the grandparents kept trying to get in touch with her, but she ignored all their calls. The grandparents and the guests who went to the party were very dismayed that Noel was not present. When the grandparents asked Marie why she did not bring Noel to the party, she simply replied, "I am his mother and I decide where he goes." To which Noel's grandmothers retorted, "Anak mo lang siya, hindi mo siya pag-aari." The grandparents seek your advice on whether there is legal basis to hold Marie liable for the damages that have suffered as a result of her acts. Alright, so this question is on abuse of right. So meron tayong nabanggit na abuse of right doon sa ating forecast. Iba nga lang yung ating situation doon sa ating example. Alright, so here is my answer. Yes, there is legal basis to hold Marie liable for damages. Under the Civil Code, there is an abuse of right when a right, although legal, is exercised in a malicious, wanton, and unjust manner. When the act is contrary to law or morals, an action for damages is proper. In this case, Marie may have the right to decide for her son, Noel, including whether to attend the birthday party. However, Marie had already promised to bring Noel to the party, which his paternal grandparents organized and paid for. Instead of bringing Noel as promised, she took Noel on an out-of-town trip impelled by her grudge against her parents-in-law for initially opposing their son's marriage to her. Thus, Marie abused her right and she should be liable for damages to the grandparents. Alright, question number 2. Razna and Junsi got married in 2015 and were blessed with 2 children, Zara and Micah. In 2020, because of the COVID-19 pandemic, the entire family had to spend 24 hours together every day in their small house. Razna observed that although Junsi continued to work from home to support the family, he began to exhibit paranoia and constantly kept making sure that they always washed their hands and rubbed them with alcohol 10 times before eating. Junsi also always wore a face mask, face shield, and hazmat in the house, except when he was alone in the room. Junsi began sleeping separately from Razna and their children. He believed that other people who wanted to meet him in person were actively trying to harm him by exposing him to the virus. In early 2022, Razna filed a petition for declaration of nullity of her marriage with Junsi on the ground of psychological incapacity under Article 36 of the Family Code, citing his atypical behavior. She presented the testimony of a doctor who proved that Junsi was suffering from psychotic paranoia due to intense stress, which accounted for his belief in things that are not real. Question, should Razna's petition be granted? Explain briefly. Okay, so this question is on psychological incapacity. Nabanggit natin yan sa ating forecast, particularly yung tan-andal versus andal. Unfortunately, iba din ang sitwasyon doon. Pero here is my suggested answer. No, Razna's petition should not be granted. According to law and jurisprudence, for psychological incapacity to be a ground for nullity of marriage, it must be of such nature that it is grave, incurable, and must have juridical antecedents. It must also render the concerned spouse utterly incapable of comprehending and performing essential marital obligations. In this case, Junsi's condition may be considered erratic or atypical, but it does not relate to his marital obligations. In fact, despite of his mental state, he is still able to work from home to support his family. Hence, the petition should be denied. Okay, question number 3. Before they married in 2000, Nonoy and Daday signed a marriage settlement wherein they agreed that their property relations as husband and wife would be governed by the conjugal partnership of gains. While the marriage was subsisting, they acquired a parcel of land using conjugal funds. The Register of Deeds issued a transfer certificate of title over the said land in the name of Nonoy married to Daday. Nonoy sold the parcel of land to Barbie without Daday's consent. Daday was not aware of the sale and did not sign the contract of sale. A year after Nonoy and Barbie signed the contract of sale, Daday died. When the children of Nonoy and Daday learned about the sale to Barbie, they questioned its validity since Daday had not consented to the sale. Nonoy's position is that Daday's consent was not required because the property was registered in his name. Is the sale to Barbie valid? Explain briefly. Okay, so this is my suggested answer. No, the sale to Barbie is invalid. Under the family code, in a conjugal partnership of gains, all property acquired during the marriage, whether contracted or registered in the name of one or both spouses, shall be presumed to be conjugal unless the contrary is proved. Furthermore, the phrase married to in the certificate of title indicates the civil status of the registered owner. When the property is conjugal, any disposition or encumbrance without the written consent of the other spouse or authority of the court shall be void. In this case, the title to the land indicates that the owner is married. Moreover, the property was acquired using conjugal funds. The sale should have been with Daday's written consent. Hence, there being no written consent from Daday, Nonoy's sale of the parcel of land to Barbie is void. Alright, next, let's see question number 4. This item has 2 questions. In 2013, Agaton, then 70 years old, executed a will wherein he bequeathed his entire estate to his acknowledged illegitimate son, Carl. Agaton entrusted the original copy of the 2013 will to Carl. In 2014, Carl joined a group of mercenaries to fight in Crimea alongside the Russians. After Russia's annexation of Crimea, Carl did not return to the Philippines and was never heard of. 5 years later, in 2019, Agaton executed a codicil which provided the following. Because of the death of Carl, I revoke my 2013 will. I hereby recognize Gian as my other illegitimate son and hereby bequeath to him my entire estate. Agaton died in 2020. During the probate of Agaton's 2019 codicil, Carl appeared in court, presented the 2013 will, contested the validity of its revocation, opposed the probate of the 2019 codicil, and sought the probate of the 2013 will. Both the 2013 will and 2019 codicil were immaculate as to form. First question, did the 2019 codicil revoke the 2013 will? Explain briefly. Distribute the estate of Agaton. Explain briefly. Okay, so ito ang mga suggested answers ko. Simulan natin sa first question. My answer is yes, the 2019 codicil revoked the 2013 will. As a rule, the revocation of a will must be based on a true cause, and if the revocation is based on a false or illegal cause, the revocation shall be null and void. Moreover, as a rule, a person may be presumed dead after an absence of 4 years if he or she is a member of the armed forces who has taken part in war. In this case, Agaton revoked the will due to his belief that Carl was already dead because he had been absent for more than 5 years since participating in the war in Crimea. Agathon's belief that Carl was already dead is valid and legal. Carl's subsequent reappearance did not make Agathon's cause for revoking the will false or illegal. Hence, the 2019 will should prevail over the 2013 will. Alright, ito naman yung sagot ko sa question letter B. The estate should be divided equally between Carl and Gian. Under the Civil Code, the preterition or omission of a compulsory heir in the direct line shall annul the institution of heirs. If there are no devices and legacies, full intestacy shall apply. In this case, Carl is a compulsory heir in the direct line, being an illegitimate child of Agathon. Gian's institution as voluntary heir to the entire estate shall be annulled, and the estate will be distributed by intestacy. Here, Carl and Gian are the only compulsory heirs. Hence, Agathon's entire estate, both free portion and legitimate, shall be divided equally between Carl and Gian. Alright, now let's go to question number 5. Joey was the legitimate son of Ron and May. Joey died intestate and was survived by his wife Kathy and their 2 legitimate children, Luis and Clarice. Several months after Joey died, Ron also died intestate. Ron was survived by his wife May, daughter Mercy, who is the full sibling of Joey, and the children of Joey, Luis and Clarice. Distribute the estate of Ron. Explain briefly. Ayan, succession. Okay, so here is my answer. Ron's estate shall be divided among his wife May, Mercy, and Joey's children, Luis and Clarice. Under the Civil Code, by intestacy, the compulsory heirs are the wife and the legitimate children. In case of predecease of any of the compulsory heirs, the children of said heirs shall be raised and shall inherit by way of representation. The wife of a deceased compulsory heir cannot represent. In this case, Ron was survived by his wife, May, and his daughter, Mercy. His son, Joey, had predeceased Ron but is survived by his 2 children, Luis and Clarice. Luis and Clarice shall equally divide what Joey would have received. Hence, Ron's estate shall be divided by 3. 1 portion for May, another portion for Mercy, and the last portion for Luis and Clarice per stirpes. Alright. Okay, here's question number 6. This item has 2 questions. Jungkook, who owns a building, leases the same to Jel with the following terms. The lease is for a period of 10 years. Number 2, the yearly rental is 1,200,000 pesos payable within the first 10 days of the current year. And number 3, in case of breach of any of the provisions of the lease, Jel is liable to pay Jungkook 5 monthly rentals and attorney's fees. 5 years into the lease, Jel sends a notice to terminate the lease and offers to pay 5 monthly rentals. Despite Jungkook's objections, Jel vacates the premises. Jungkook sues Jel for the rentals due for the remaining 5 years of the lease. Jel takes the position that her liability should only be limited to 5 monthly rentals and attorney's fees. Question letter A, is there a penalty clause in the lease agreement? Explain briefly. Letter B, as between Jungkook and Jel, who is correct? Explain briefly. Ayan, sa mga mahilig sa Korean novela or ano ba to, K-drama, ang tanong ba ay pang Korean novela? Okay, so here are my suggested answers. For letter A, yes, there is a penalty clause in the lease agreement. Under the Civil Code, a penalty is a stipulation for damages in case of breach of the contract. It may be claimed by the creditor without need of proof of actual and other damages. In this case, Jungkook and Jel stipulated in their contract that in case of breach of any provision of the lease, Jel is liable to pay Jungkook 5 monthly rentals and attorney's fees. Thus, a penalty clause was agreed by the parties. Okay, for letter B, my answer is Jel is correct. Under the law, when a contract is breached, the creditor is entitled to sue for performance or rescission with damages in either case. The damages may be that which may be proved or that which may be agreed upon by the parties as penalty or liquidated damages. In this case, there was a breach of the contract, particularly the term of the contract, as Jel had pre-terminated it. Jungkook's options were limited to the penalty clause of their contract. Instead of the right to sue on the full rental for a year, the agreement restricted him to recover and Jel to pay 5 monthly rentals only and attorney's fees. Thus, Jel is correct that her liability should be limited to 5 monthly rentals and attorney's fees only. Yeah. Okay, now let's go to question number 7. So, Brenda saw the online advertisement of Evelyn, who sells limited edition sneakers. Through an exchange of text messages, Evelyn and Brenda agreed that Evelyn will sell to Brenda a pair of brand new sneakers for 25,000 pesos. Number 2, Brenda will deposit the purchase price in Evelyn's bank account. And number 3, Evelyn will deliver the sneakers within 10 days from deposit. Brenda deposited the purchase price and Evelyn acknowledged receipt thereof. Before the delivery of the sneakers, Evelyn received an offer from Rosella to pay or to buy the same sneakers for 35,000 pesos. Evelyn candidly tells Brenda that she is selling the sneakers at a higher price to another buyer and sends this text message to Brenda. Sis, may iba pala akong buyer na mas malaki yung offer. Sorry, balik ko na lang bayad mo. Carrie? Evelyn claims that since the sneakers have not yet been delivered to Brenda, she can still withdraw the offer. So, the question is Evelyn's contention tenable? Explain briefly. Ayan. So, ito question na to, may pagka-reciprocal obligations. No? Pero, although yun ang hula ko sa aking fishbowl, o yun ang hula ng fishbowl ko, pero iba naman kasi yung sitwasyon na binigay niya. So, anyway, here is my suggested answer. No, Evelyn's contention is not tenable. Under the Civil Code, upon the perfection of the contract, there arise reciprocal obligations of the parties. In a contract of sale, the seller is bound to deliver and transfer ownership of the thing, while the buyer is bound to pay the price. In this case, Evelyn and Brenda had a perfected contract when they had a meeting of minds over the sale of a brand new sneakers for 25,000 pesos. Brenda had deposited the purchase price as agreed. Evelyn was bound to deliver the item. She could no longer withdraw the offer as it was already accepted by Brenda, and more importantly, Brenda had already performed her end of the contract. Thus, Evelyn should deliver the sneakers to Brenda. Okay, let's now go to question number 8. So the question is, in 2017, Alma orally sold a parcel of unregistered land to the spouses Ray and Shane for 500,000 pesos. Upon receipt of the initial payment of 350,000 pesos, Alma delivered possession of the land to the spouses. Shortly thereafter, Alma died. In order to formalize the sale, Ray and Shane convinced Josie, one of Alma's children, to sign a notarized deed of confirmation of sale. In consideration thereof, Josie received 150,000 pesos, representing the balance of the purchase price. On the strength of the notarized confirmation of sale, the spouses were able to transfer the tax declaration of the property in their names. Later, Josie died. In 2020, the surviving children of Alma discovered the oral sale of the land to Ray and Shane. They demanded the return of the property on the following grounds. The oral contract of sale is void because it does not appear in a public instrument. And number 2, assuming the sale is not void, it is unenforceable under the statute of frauds. Ray and Shane insisted that the sale of the land to them was both valid and enforceable. Question, are the contentions of the heirs of Alma tenable? Explain briefly. Alright, so ito naman ang aking suggested answer. No, the contentions of the heirs of Alma are not tenable. Indeed, under the Civil Code, the sale of real property should not only be in writing but must also be in a public instrument. However, these rules are only for convenience and enforceability. An oral sale of real property is valid and may be enforced if it is partly or fully consummated. In this case, the sale was originally made between Alma and the spouses Ray and Shane. A portion of the purchase price was already paid by the buyers. The balance was paid to Josie, one of Alma's children, because Alma had already died. Although it was only Josie and not all the heirs who executed the notarized deed of sale, this is an issue between the heirs which did not render the original oral sale invalid or unenforceable. Hence, the other heirs of Alma cannot assail the sale. Okay. Question number 9. Ida, for the consideration of 5 million pesos, sold her parcel of land to Lorna as evidenced by a notarized deed of sale. Lorna, however, failed to deliver the amount in full, paying only 500,000 pesos as down payment. Because of the non-payment of the balance, Ida simply sold the same parcel of land to Fe with the intention of returning to Lorna the 500,000 pesos down payment. Question: who among Ida, Lorna, and Fe owns the property? Explain briefly. Yan. Napapakatatuloy tayo ng si Ida ba si Lorna o si Fe? Okay. My suggested answer is Lorna owns the property. Under the civil code, in sales, ownership is transferred to the buyer either by actual or constructive delivery. The execution of a public instrument such as a notarized deed of sale is a mode of constructive delivery. The failure of the buyer to pay the price simply gives the seller the right either to demand payment or to rescind the sale. In this case, Ida sold the property to Lorna and they executed a notarized deed of sale. Ownership has already transferred to Lorna. Lorna's failure to pay the balance of the purchase price did not revert ownership to Ida. Ida should first either demand payment of the price or properly rescind the sale. Thus, no longer the owner of the property, Ida could not sell it to Fe. Yan. Okay, let's now go to question number 10. At eto, taga-swak na swak. Nahulaan natin to. Nahulaan na ating fishbowl. So ano ba yung tanong? Tara, let's read it. Question number 10. Laika and Jessica, who are best friends, are both engaged in money lending at predatory interest rates. Running out of funds, Laika borrows 2 million pesos from Jessica for 2 months at a monthly interest rate of 10%. Jessica releases the borrowed amount after Laika signs a promissory note. Laika then relends to Monica the borrowed amount of 2 million pesos for 2 months at an interest rate of 30%. After 2 months, Laika fails to pay Jessica, prompting Jessica to file a collection suit against the former for the 2 million pesos principal and 10% interest per month pursuant to their agreement. Laika counters that the monthly interest rate of 10% is exorbitant and should be reduced to the legal rate of interest at 6% per annum, which between the positions of Laika and Jessica is tenable. Explain briefly. Ayan na, si excessive, exorbitant, at unconscionable interest. O, diba? So, kaya sana naalala nyo ang hula ng ating mahiwagang fishbowl. So, eto na ang aking suggested answer. Laika's position is tenable. Under the law and jurisprudence, exorbitant, excessive, and unconscionable interest on loans is void. The willingness of the parties to stipulate on such void interest is inconsequential. In this case, the monthly interest rate of 10% is highly excessive, exorbitant, and unconscionable. This monthly interest rate would make the interest rate at 120% per annum. There is no estoppel here. Even though the parties voluntarily agreed on the said interest rate, it does not make it valid. Hence, Laika is correct, and the interest rate should be reduced to the legal rate of interest at 6% per annum. Okay. Now, let's go to question number 11. The question is, Leon is the owner of a condominium unit located directly above the condominium unit owned by Ange. In 2014, Leon undertook renovations in his unit's bathroom, which caused water to leak from his bathroom down to Ange's unit and caused extensive damage to Ange's belongings. As Ange had obtained property insurance on her unit and its contents from Proverbial Insurance Company or PIC, Ange was able to recover the value of the damage in September 2016. In October 2022, PIC, as subrogee of Ange, sued Leon to recover the insurance proceeds it paid to Ange. Leon interposed prescription to dismiss the suit of PIC. PIC counters that the payment of the insurance proceeds in 2016 created by way of legal subrogation a 10-year period within which to file the suit against Leon. Is PIC correct? Explain briefly. Okay. My suggested answer to the question is no, PIC is incorrect. Under the Civil Code, the prescriptive period to recover based on a quasi-delict is 4 years, counted from the occurrence of the negligent act resulting in damage. This limitation applies also to the subrogee who assumes the legal right to collect a claim of another. In this case, the subject incident happened in 2014. PIC paid Ange in 2016, but PIC as subrogee of Ange only sued Leon, the negligent third party, in 2022 or 8 years after the incident. Hence, PIC's action has already prescribed. Okay, now let's go to question number 12. Gio, single, joined a marathon organized by Takbo Company. For lack of alternative routes, the marathon course included a public road which was not blocked off from vehicles. Takbo Company solicited the sponsorship of Kotse Corporation for added financial support. Gio was hit by a jeepney driven by JD on the public road and died. The parents of Gio sued Takbo Company and Kotse Corporation for damages. The court ruled that Kotse Corporation is solidarily liable for damages with Takbo Company for being one of the principal movers of the event due to its sponsorship. Okay, the question, is the court correct? Explain briefly. Yan. So my suggested answer is this. No, the court is not correct. Under the Civil Code, solidarity is not presumed. There is a solidarity liability only when the obligation expressly so states or when the law or the nature of the obligation requires solidarity. In this case, neither law nor contract required solidarity. The marathon was organized by Takbo Company. Kotse Corporation only added financial support. It did not have a hand in the preparation and conduct of the marathon. On the contrary, Takbo Company as organizer was solely responsible for the safety of the marathoners. Thus, the complaint against Kotse Corporation should have been dismissed. Okay, now let's go to question number 13. Eka, a Filipina, and Dugil, or Duguil, a Korean, married in the Philippines. Thereafter, they moved to Seoul, South Korea. While there, Duguil began to ignore Eka. He was always out with his friends and usually came home drunk. When Eka could not take their marital situation anymore, she asked for a divorce. Dugil agreed on the condition that Eka would be the one to file for divorce and that the ground should be no fault, meaning neither of them is at fault or neither would be accused of any wrongdoing. After the divorce, Eka went back to the Philippines and filed a case to have the judgment of divorce recognized. The regional trial court denied Eka's petition because she alone filed for divorce in violation of the second paragraph of Article 26 of the Family Code. According to the RTC, Article 26 requires that either the foreign spouse alone initiates the filing of the divorce or at the very least, Eka and Dugil should have filed for divorce jointly. Is the RTC correct? Explain briefly. Nako, napaka-favorite talaga ng tanong to. 3 taon na straight tinanong itong foreign divorce in the bar exam. So nahirapan pa ba kayo dito sa tanong na to? Pero at any rate, ito ang aking suggested answer. No, the RTC is not correct. Article 26 of the Family Code provides that when a Filipino is married to a foreigner and a divorce is validly obtained, which capacitates the foreigner spouse to remarry, it may be recognized here in the Philippines and it capacitates the Filipino spouse as well to remarry. This provision has been interpreted in Republic versus Manalo as to recognize the foreign divorce even if filed by the Filipino spouse. In this case, Eka, a Filipina, was married to Dugil, a Korean. They moved to South Korea and obtained a divorce there. That divorce may be recognized here in the Philippines in a proper petition with proof of the foreign divorce, the law of the country where the divorce was granted, and the national law of the foreigner spouse which allows divorce. Thus, the RTC should not have denied the petition. Okay, now let's go to question number 14. During Remy's pregnancy, her father Gavin executed a will bequeathing his rest house in Calatagan, Batangas to Remy's unborn child. While Gavin and Remy, who was then 7 months pregnant, were on their way to Calatagan, they figured in a car accident on December 1, 2021. Which resulted in the instantaneous death of Gavin and the premature delivery of Remy on the same day. At 8:30 a.m. on December 3, 2021, the newborn baby died. Is the device in favor of the baby valid? Explain briefly. Alright, my suggested answer is yes, the device in favor of the baby is valid. Under the Civil Code, personality begins at conception. A conceived child shall be considered born for all purposes that are favorable to it, provided it is born alive, if it had an intrauterine life of 7 months or more, or born alive and stayed alive for at least 24 hours, if it had an intrauterine life of less than 7 months. Thus, an unborn child can be the recipient of a donation, device, or legacy. In this case, Gavin bequeathed through his will his rest house to Remy's unborn child. Gavin was aware and conscious of Remy's soon-to-be-born baby. The baby had an intrauterine life of 7 months but was born alive and stayed alive for 2 days, more than the time prescribed by law. Thus, the device is valid and may be received by the child's heirs. Okay, last but not the least, question number 15. This item has 2 questions. Miguel, who died single and childless, was survived by his 2 legitimate brothers, Romy and Rolly, and his nephews, Arno and Pabs, the legitimate sons of his predeceased legitimate brother, Edgar. Before his death, Miguel executed a 1-page notarial will, inclusive of an attestation clause and a notarial acknowledgement, with only 1 testamentary disposition bequeathing his entire estate to Romy and Rolly. The will was not paginated and was attested by 4 witnesses, 1, 2, 3, and 4. It was the eve of Cuatro's 17th birthday when the will was executed. The will was written in the Ilocano dialect, which Miguel knew and understood, but the witnesses did not. Miguel and the witnesses signed at the end of the testamentary disposition. The attestation was also written in the Ilocano dialect, which, when translated to the English language, reads as follows. This will of Miguel was written in 1 page. We, the attesting witnesses, signed at the end of the will and at the bottom of this attestation in the presence of Miguel and each of us. Each of the 4 witnesses signed below the attestation clause. Because none of the witnesses knew and understood the Ilocano dialect, the attestation was interpreted to them by Miguel's lawyer who was present to notarize the will. So question letter A. Does the fact that the will was written in a dialect known only to Miguel invalidate the will? What about the absence of the marginal signatures of the testator and the witnesses? Explain briefly. Letter B. May the will nonetheless be admitted to probate? Explain briefly. Alright, so my suggested answers to question number 15 with sub-questions is letter A. No, they did not invalidate the will. As to the dialect or language in which the will is written, the Civil Code only requires that it be understood by the testator. The law also provides that if the attestation clause is in a dialect known is in a dialect or language not known to the witnesses, it shall be interpreted to them. Finally, as to the signatures, the law requires that the will be signed on each and every page thereof. In this case, the will was in the Ilocano dialect or language known and understood by Miguel. Although the witnesses did not understand it, the attestation clause was nevertheless interpreted to them. Lastly, the will complied with the signature requirement. It was a one-page will, and the testator and the witnesses signed at the end of the testamentary disposition. Thus, there was no need to sign on the left margin. Hence, the alleged defects are not fatal to the will. Alright, for question letter B, yes, the will may be probated. It is settled that in probate of wills, the subject of inquiry is the testamentary capacity of the will of the testator and the due execution of the will. The intrinsic validity of the will is not a proper issue. In this case, there is nothing to show that Miguel's capacity to execute a will was impaired. Also, the will had substantially complied with the formal requirements of the will. Thus, it may be allowed. The end. So yan po ang part 1 ng civil law. At yun ang aking mga suggested answers. So, like I have said last year, no, doon sa aking mga suggested answers, maybe my answers are as good as your answers. The only answers that matter in this case are the answers of the examiners. Pero hopefully, you know, yung sagot ninyo, yung sagot ko ay close to those of the examiners. But rest assured, these answers were based on the law and jurisprudence. And by the way, sinagot ko ito within only, 2 hours, 3 hours. Sinubukan ko, trinay ko na i-approximate yung same time as as our examinees answer the question. So kaya kung may mali ako dyan, at saka kung sa tingin nyo, mas ito yung sagot ko, or ano ba, please comment down below. Magdiskusyon tayo. Tara, magdiskusyon tayo. Okay, so maraming salamat. This is just part 1. Meron pa susunod yung Civil Law Part 2. Abangan nyo po yan sa aking next video. Thank you for watching. Lagi tatandaan, isip ay buksan, alamin ang batas. Bye guys!